This conference will now be recorded.
Okay, good morning, everyone. This is Wednesday, January 13th, 2021. Hard to believe we're already into 2021. Seems like 2020 couldn't leave soon enough. Let me get started here just right away with our forms changes. So these are the 2021 forms changes coming from Oregon Real Estate Forms. There are a few that are of significance. Not a lot of major changes, but things that we do need to talk about. And if you have any questions at all, feel free to unmute your mic and just let me know, or put up a chat or something so I know what your questions are. So getting started right away with the residential sale agreement, the most important one that we always use every single day. So the residential sale agreement, the first change starts on line 45, where we talk about fixtures, controls, and keys. The change here is all fixtures and essential related equipment, remote controls, smart home features, that's a new one that's been added in there, are to be left upon the property. So in other words, taking into consideration the changes that have been made with new construction, smart home features, or even homes that have been renovated to include smart home features. So that's the first thing that is of a change here on line 45. That's reiterated a little bit more on line 284, in which we talk about smart home features with more detail. So does the property contain any smart home features? If yes, the seller to identify all smart home features in writing within 3 business days of the date this agreement is signed and accepted. In addition, seller to provide necessary information for buyer to access said smart features at closing unless otherwise agreed in writing. So in other words, I would suggest when you get a new listing, ask your client at that point in time, what are the smart home features? And get your list as part of your listing. It would be nice to even have that as an attachment to your listing, as a document there, so you can have that done already. Smart home features, of course, would be things that are considered smart within the home that could be done through electronic methods, controlled remotely by an app, often, such things as like those doorbells. Understand also, a smart home feature becomes a fixture when it's actually screwed into and attached to the building. So people will retrofit things with a new doorbell that has those cameras in there. When that's done, it becomes a fixture. And so that's something that would need to be included in the sale. So it's important to recognize this. Are the smart home features, yes, known, or unknown? And if yes, to have those identified. Again, suggest having that done at the point of time when you take the listing. So that's one of the bigger changes here on the residential sale agreement. Also, something to take into consideration on line 316, how the earnest money deposit will be payable. We always had before by wire transfer or check. Well, there's other means now to deposit money into escrow or into a client trust account. And so that has been removed, and now it's recognizing that just the deposit will be payable and deposited within 3 business days, not specifying wire transfer or check. It's by whatever means it can be done. And then also line 322 to 325, upon deposit of earnest money, in accordance with this agreement, the buyer shall take no steps to withdraw or authorize withdrawal of said funds, except in accordance with the terms and conditions of this agreement. In the event buyer attempts or succeeds in any such withdrawal of the earnest money deposit, it shall be considered a breach of this agreement and will result in a forfeit of the earnest money deposit and termination at the option of the seller of the buyer's right to purchase. So that's reiterating the fact that the buyer has no right to unilaterally take that money out of the earnest money or out of escrow or a client trust account. So that's really important, unless, of course, the seller agrees to it or there's another method for them to take it out that's agreed to within the purchase agreement. Major change there. Also, this is kind of a minor thing, just the definition that buyer and seller, any reference to buyer seller includes singular and plural. It's already defined other places, so they just took that out of the definition section. Not a big change. This is important here too, because it's always been somewhat confusing for the utilities transfer. So we've always had before that utilities are transferred at closing. Now it's at the date buyer is entitled to possession. So take that into consideration. It used to be at closing, but now because we have buyer occupancy before closing, we also have seller occupancy after closing often. So now we're not transferring utilities until the date the buyer is entitled to possession, unless the parties agreed otherwise in writing. This makes much more sense. Also, this has been done in every single one of our purchase agreements. The address, the phone number, and the email of the buyer and the seller are removed from the sales contract. Often I will see these not included in any way in the sales contract. The reason they're there is so that the escrow company has an easy way of getting this information, and they need it. But now it's been removed from the sales contract because a lot of brokers don't like the other party to have direct access to their clients through this means. And so it's been removed, but now it means we have to make sure we have that added step of notifying escrow what your buyer's name is, their address, their contact information, or your seller for that matter. So it's up to the agent to make sure that information gets transferred to escrow. So it's been removed from pretty much all our sales agreements. So that's basically the residential sale agreement changes. So here's where it is also off the seller. Oh, Tina, you want me to go back to line 285, excuse me. Yes, basically here is the line 285 about smart home features. So I was asked to explain this a little bit more. So does the property contain any smart home features? You answer yes, no, or unknown. If yes, the seller needs to identify all those smart home features in writing within 3 business days of the date of this agreement. So it could be such a thing as they're including their refrigerator, and it's a smart refrigerator that you can remotely check to see the contents of the refrigerator, whatever different kinds of smart home features that there may be. I suggest at the point of time when you take the listing, you ask your seller, do you have smart home features within this property? And if the answer is yes, ask them to note all the list of what those features are. Because now it's required that if, yes, the seller needs to provide that information within 3 business days of the agreement to the buyer. So it's really important. And they also need to make sure at the point of time of closing, the buyer has access to all the smart home features, all the information on how to work them. Does that answer the question there, Tina? Thank you. Okay, very good. Okay, let's move on to the next. So now into farms, ranches, sales agreement. Basically, one major change here regards to the FIRPTA involved with the for Agriculture Foreign Investment Disclosure Act. The line in which it said clients who are foreign persons should consult with their attorney regarding this requirement about FIRPTA. It's been changed to now foreign persons who are buying or selling real estate are advised to seek proper legal advice regarding this act. So it's just been changed just a little bit, just a matter of just a few adjustments. It means the same thing basically. That's the change there. Hi, Eric. I am recording this, and so anything that you've missed will be available on the recording, so you can just listen to the beginning right away. New construction sale agreement. Some changes here in the licensed professional inspection section. Buyer shall have 10 business days after the date the seller has delivered to buyer the certificate of occupancy. That has always been a question. You know, the seller will tell you the house is done, but they don't yet have the certificate of occupancy. So again, the professional inspection should start upon receipt of the certificate of occupancy, and it should be at the point of time in which the seller has now said the house has passed its final inspection. It now, according to the government, is available for occupancy. At that point, that's when the timeline starts for your home inspections. So anyway, that's an important change. It clears things up. It makes it much more. It makes a lot more sense. And again here, the change crossed out for the address and phone number and email for the seller and the buyer. And it's also on the counteroffers too. Commercial sale agreement, change in this one. This is an important change here on the disclosure law within the commercial sale agreement. Line 220, 221. No seller disclosure form as noted in this provision is required for property that is commercial or vacant land. However, if the property includes as part of the improvements a 1 to 4 residential dwelling, the form should be utilized as required by statute. So in other words, if you are purchasing a 1 to 4 unit residential dwelling in which, a lot of people are a little confused about that requirement, in which the buyer or their immediate family member will be moving into one of those dwelling units, then at that point, the seller's property disclosure is required. If the buyer of those 1 to 4 dwelling units is not planning on occupying it, really the statute does not require the seller provide that. It's often done, it's usually done, but it's not necessarily required. That doesn't negate the fact the seller is required to let the buyer know about anything they know about the property that could be of confusion, but the actual property disclosure statement is actually required for the transfer of ownership of a dwelling unit in which the buyer intends to reside or their immediate family member. Anyway, on a commercial sale, it's not required. So it's cleared on that. The vacant land sale agreement, change here is just a matter of semantics. This was changed a while ago, in which we had the Town Home Plan Community Homeowners Association named Addendum, and it was changed I think last year, maybe the year before, to the Homeowners Association Town Home Plan Community Development. All they did was they switched that to the vacant land sale agreement. It was an oversight. They hadn't changed the name of that addendum. And now they're also saying that if the vacant land is part of a homeowners association, obviously we need to have the homeowners association addendum attached to the sale agreement. So that's important change. And again, removal of the contact information of the seller. The residential condominium sale agreement changed as far as the removal of the contact information. The manufactured home and park sale agreement. Now, we don't use this within our brokerage because we are not licensed to sell manufactured homes and parks, but a change here disregarded the removal of the word all before keys. And again, removal of the actual contact information as far as the address and phone number. The seller's property disclosure statement. This is something that's often overlooked. Nothing's been changed as far as the verbiage in the document as to what is required that the seller disclose to the buyer. It's just this very last section, line 203, in which you're supposed to fill in the number of pages of explanations. So if there's any attached explanations, you're supposed to fill the number. And basically that's been removed just to say number of pages of explanations are attached, so that figure as far as 0 if not filled in. So that's been changed. Often that's just forgotten. People don't see that line. New construction inspection addendum. That again has been changed here, in which we're talking about the substantial completion of construction at the buyer's expense. The buyer may have the property and all elements and systems thereof inspected by one or more professionals. The default date from 5 to 10 is the change here. For the buyer shall have 10 business days after the date of seller's written notification to buyer of the date of the issuance of final occupancy to provide the seller with a written punch list of items. So instead of 5, which was the default is now 10. But of course, any number can be filled in there and negotiated between the buyer and the seller. Now, the seller's property disclosure statement addendum. They basically now have changed just the name of this explanation of any of those yes responses to the seller's property disclosure statement, which have the asterisks that are required to have a written explanation. We're now just calling it the Seller's Property Disclosure Statement Addendum. It now has an official name. So just that's the only change here, just the name of it. So if you're looking for it in your forms library, that's what it's called now. Historic Property Advisory. This is a new form. And the whole point of this form is so that the buyer and the seller can understand what the historic property really is. And so it's an explanation. It does not need to be signed by both parties as part of the transaction. It is signed by whichever party you are representing. So this is just an advisory to let people know about if something is designated historic, it must meet specific qualifying criteria. And again, that historic properties have special tax consequences. And if buyer and seller do not understand these consequences, they're advised to seek competent legal or accounting advice. So again, this is just a copy of the full advisory. It will be in your forms library. And as you can see here, for more information, let me go back. They say to go to www.oregonheritage.org. So again, the special assessment granted for a period of 10 consecutive property tax years. Obviously, the tax consequences of having your property designated historic is significant. So it's important for people to understand what this means. But it's also tied into now the Historic Property Addendum. This is a new form as well. And this basically is something that should be filled out by the seller and be used as an attachment, just like the lead paint addendum is used, again, filled up by the seller and is used as an explanation to the buyer. So this is something that the seller will fill out. And again, they're answering these questions. Is the Historic Property Advisory is attached for additional information? Is the property currently on the National Historic Register of Historic Places? Yes or no? Is it utilizing the special tax assessment through the State of Oregon Park Service? Yes or no? If yes, when will the special tax assessment expire? This is just, again, important information for the seller to provide to the buyer. And a full copy of the addendum is right here. So again, it's to be filled out by the seller, just like they would be filling out the lead paint disclosure. Hopefully there's no questions on that. The buyer's representation agreement, which is, we also call it the buyer's contract, the buyer's service agreement, has a number of names, but it's now called the buyer's representation agreement. Again, I really recommend people utilize this as much as possible when you're working with buyers. I mean, it's always so frustrating when you've worked with a buyer for 6 months and you've been showing them property, researching things, working really hard, and then you find out they've gone off on their own and bought directly from a listing agent. It's just so frustrating. If you have this contract in place, you are protected. So basically the change to this agreement, it used to have it, this whole section about it, they're appointing the principal broker and the buyer's agent is now, the whole point about hiring the principal broker has been removed. Is now saying they're working with the broker and the brokerage. So those are the changes in the first section here, collectively referred to as broker. And the information, as you can see here, for clarification purposes, client shall include any client, any legal entity in which the client owns or controls directly or indirectly more than 10% of the shares or interests, and any third party is acting under the direction or control of any of the above parties. For instance, you have it filled out that you're working with Joe Smith, and Joe Smith is actually also an LLC, an S Corp owned by under a different assumed name. This is basically taking now into consideration if Joe Smith wants to write an offer under his LLC, we're now protected with that. So the change here is, there's just a few changes here. It talks about the term, the agreement shall commence instead of immediately, is now upon signatures of all parties and will terminate at 5 p.m. on a specific date, period. The termination of this agreement prior to stated terms shall be as follows, and you check one of these. Either party can terminate this agreement with written notice to the other party without further obligations, or if client terminates this agreement Client shall pay broker an early termination fee as follows for all expenditures incurred by broker. So I personally would like this. I would think for protection of all your time and energy, that box on line 23 should be clicked, just because if they do go off and write with someone else other than you, then they could, if box number 22 is checked, they can say, well, I terminated, I'm done, so I'm not working with you anymore. It basically makes this whole contract worthless. But if there's some little teeth behind this and says, if you terminate early, you're going to pay me a fee of, I don't know, $5,000 for my time and energy, something like that. So, and again, here it defines more the kind of property that you could be looking for, property such as residential, income, whatever. And then also the representation. The client is acknowledging they've received the initial pamphlet, and the client has read. The broker shall act as the agent of the client, and this is basically what it's saying. It's just changing buyer's agent to broker. Also compensation, how this all works. Client agrees to work exclusively with the broker, and upon successful sale and close of escrow shall pay the broker as follows. And it's all this section regarding a fee has been removed. Instead, now we're talking about commission. So commission agrees to pay broker a fee of a flat fee, so in other words, a dollar fee or a percentage of the purchase, lease, or option price. Typically, the way most of our brokers work utilizing this form is they will put in that under additional provisions, right here under additional provisions, that the seller is paying the commission through a cooperative agreement, or that the fee noted in MLS is the fee that the broker will receive. So there's been quite a few changes within this form. Also the line 62 about the pursuant to the National Realtors Association Code of Ethics, client consents to broker being compensated by more than one party in this transaction involving client if broker's commission is being paid or offset by the seller or listing broker. Now, one thing to recognize about the buyer's representation agreement, you could negotiate any fee you want. So say you negotiate with your buyer, I need to be paid 3.5% at the point in time in which I have a closing with you because I'm going to be working really, really hard. And you find out in the cooperative agreement that the listing agent, the listing brokerage, is paying 2.5%. The buyer then has agreed to pay the difference between the two. So they would be paying that 1% difference. And so this line here, 6263, explains that there's a cooperative agreement noted in MLS, or not necessarily in MLS, there may be a cooperative agreement involved with some of that commission. Okay, I like the disclosure section in here, which is basically, again, letting that client know we are here to represent you. There's a lot of things that you may have questions about, such as hazardous materials land use. And again, we are advising you to seek proper advice on that. We are not qualified to answer those questions. So this is a lot of changes within this particular form, but I think they're good changes. And again, the additional provisions is where you can write in that section, because again, most of our brokers do note that commissions to be received are what is cooperated within MLS. But again, you have that option to negotiate a different commission with your buyer if you wish to. And again, the buyer's representation agreement needs to be also signed by the broker. Okay. Now, the agreement to occupy before closing. This is a good adjustment to this form. This has always been a bit confusing too. Line 32, the buyer shall at buyer's sole expense maintain all utilities and services. So just like we have within the change within the residential purchase agreement, in which the change for when utilities transfer is at the point of time when buyer gets possession, is also now noted here in the agreement to occupy before closing. The buyer shall maintain all utility and services at the point in time which they take occupancy. The agreement to occupy after closing has the same thing. The seller shall, as seller sole expense, keep and maintain all utility and services in good working order. So in other words, the seller is responsible to make sure it's working, but the buyer is the one responsible for the payment at the point of time when they, excuse me, in this case, the seller is responsible to keep all utilities going after closing because they are still in possession. Okay, notice of buyer's unconditional disapproval. When the buyer unconditionally disapproves of the home inspection, this form has been used. There's been a change here in which we have the broker note and sign at the point of time when they receive the notice. Because remember, delivery of notice to the other side notes delivery to the principal in the transaction. So in other words, the broker who's receiving the notice on buyer's behalf to sign and date, and then also the seller at the point in time it's delivered has received that notice. On the investment property addendum, again, document review period. The change from commencing on the next business day following the end of seller's delivery period, now it's been changed to saying commencing on the next business day following delivery of available documents to buyer. So in other words, that's the document review period. The next business day after they've been delivered to the buyer, that's when the clock starts for the 5 business days to review the documents. So it was after the delivery period. The delivery period, I don't remember exactly what it was, but it's actually after the documents have been delivered. So they've been delivered within the delivery period. Say the delivery period was 5 days. They were delivered on day 2. Now the clock starts on day 2 or on day 3 is when it starts. That makes sense. Smoke and okay, if the documents are delivered at different dates, when does the timeline start? Good question. It should start for the review of each of those documents. Say you get, for the investment property addendum, you're getting copies of the CC&Rs on a specific date. The review of the CC&R should be from that point in time, but you don't get the leases until maybe the end of the delivery period. You still need to have those full time to review those leases as well. So that's really important, Tina. I totally agree with that. You need to be able to have the full amount of time for each of those documents. So if they're not all delivered in one fell swoop, you need to have time to deliver and to review them based upon once you receive them. Now the smoke and CO advisory. This document did exist before. It's been brought back. So this is an advisory. It just explains the importance of smoke and carbon and dioxide alarms, and carbon monoxide alarms. It's something that could be used for your seller or your buyer. It's to be signed by one or the other. It's not usually part of the transaction. It's something that is part of information to provide to people. I think it's good and helpful, and it has an information here on the Office of the State Fire Marshal. It's something I will put into our lists of something to be looking at, and I think it'd be important to have it as part of something that you would always be providing to your client, a smoke and carbon monoxide advisory. It explains to our sellers pretty well why we have to have these things working and is required by state law, and for the buyers, the importance of making sure that they know about it and why it's required. The septic on-site sewage system addendum, there's been a couple of significant changes, but I think this is really important. The buyer's right to terminate the transaction. The buyer shall have 5 business days, if not filled in, to receive the written report or statement. The or statement's been removed. So in other words, you can't terminate based upon a statement any longer. You have to have received a written report. That's important information. So the written reports, all that stuff, documents and information, no written reports. The private will addendum to the residential sale agreement. This was changed because there was a conflict between what this line said and what we could negotiate. So in other words, the buyer's testing duties, within 5 business days after buyer and seller has signed this agreement, buyer may, at buyer's expense, order well testing of the additional professional tests. Well, we're also saying, we're negotiating, saying, no, I want the sellers to pay for the additional well flow tests or the additional arsenic tests. So the buyer testing duties, that was removed at buyer's expense because it's a matter of negotiation. The buyer is the one who provides the seller with a private well addendum as part of their purchase agreement. And the seller can come back in a counteroffer and say, no, I'm not going to pay for the well flow test. Buyer can do it themselves, but it's going to be under their expense. So that line was removed. Makes sense. Buyer's contingent right to purchase. There's some changes in this document. Some of these I think are, you know, this form has always been somewhat confusing to a lot of people. I know the year before, the Forms Committee wanted to have it all in one form, and they did, but they neglected the way any notice that the property could be in bumpable status in MLS as a result. So that was adjusted, but also the contingency here. It's important to note here the change on the contingency. Buyer, you know, the buyer's contingent right to purchase. The buyer cannot perform on their purchase unless they sell their home. And this form is used when the buyers have either not listed their home, or it is listed, but does not yet have an offer on it. This form, this change on line 7 here, notes that the buyer may not accept an offer on their home that is contingent upon the occurrence of another sale without the seller's advance written consent. In other words, the buyer can't accept a contingent offer on their own home without the seller saying that's okay with them. I always call this a house of cards. Buyer 1 can't purchase the house that they want unless they sell their home. Buyer 2, who's going to purchase the buyer 1's home, has to sell a house. That's a contingency for them, and their house is not yet in contingent, it's not in pending status. So that line here says basically that if the buyer wants to accept that offer on their property, but it is contingent upon buyer 2 selling their home, they got to have our seller's acceptance of that contingency. So basically, it's still utilizing the same notices as before. Notice 83A, that the buyer has accepted a written offer. They have received a acceptance on their property, and you know, there's just some changes to some of the verbiage, and there's some changes to the notice of the seller having received a second offer on their property prior to the buyer's response deadline. So just some changes to some verbiage here. It's the same as before, but there is the wherewithal for the property to be in bumpable status. That's now been added in there. So also here is an important change here too. The commencing on the buyer's delivery of buyer's response to seller having selected alternative 1. The buyer's right of revocation period under seller's property disclosure statement applicable commences upon the latter of the following events: the delivery of the statement to buyer or buyer's broker, or when the sale agreement is signed and accepted. So this is, what's the timelines? The contingencies and timelines. Do they start upon the point in time when the buyer has their home in pending status, or does it start upon the point in time in which we've got an agreement, even though it's a contingent agreement? So you pick which one is appropriate. And I think that's most of the changes, some additional lines to explain some contingencies in there. And that's it as far as the forms changes. So do we have any, I got some questions here. Does anyone have questions on the forms changes? If so, you can unmute your mic before I go into or put a chat down. And as for information, before I get going on to market. If not, so let's get going on what's happening in the market. Okay, there's been some really interesting things that's been happening this year, and I have to say our market, who would have thought that what's happened. So when we look at what's happened in 2020 and moving into 2021, recognize that our knowledge of our market is a really important tool that we have. It's how we come across as professionals. It's how we can let the public know that we are among the people who really understand our real estate market. And it helps us enforce our status as experts in what we're doing. So as we move into 2021, let's talk a little bit about what has happened. So over 2020, these are some of the things that were really significant. We looked at what happened as the years leaded up to the housing crash, that there was massive home appreciation. But over the last 6 years, home appreciation was more modest, and that's true across the country. The months of inventory of homes for sale that during the crash, the inventory after the crash, we had a lot of inventory, obviously months and months and months. But today we have, as we know, hardly any inventory. So here, the amount of money, the way people were leveraging their home, refinancing things, how much home equity was cashed out was over $824 billion between the years of 2005 to 2007. We all know people were using their home equity, robbing Peter to pay Paul, which really contributed a lot to the market crash. But then when you go into what happened leading up to 2020, people weren't doing that. They weren't leveraging their home really at all. There was very little taken out. But also something to think about what has happened in today's market. Of all the homes in America, at least they have at least 60% of their home in equity. Americans are sitting on tremendous equity. 42.1% of all homes are owned free and clear. And the average equity of mortgage homes is $177,000. That was leading up into 2020. During the last, prior to the last 5 recessions, this is information that we had in March of 2020. This is what home price happened during the recessions. Of course, 2008, we know home prices were devastated. The average home went down 20% in value. But during these other recessions, 2001, 1981, 1980, actually homes went up in value. There was a reduction in home prices in 1991 of a small amount. But during the last 5 recessions, this is what happened. But now we can add a new recession into it, the recession of 2020. And actually during the recession of 2020, home prices went up 7.3%. So this shows you that having a recession does not mean that we are going to have homes and their home value be devastated. What happened in 2008, that recession was due to the housing market. It really was. People were purchasing homes who did not, in today's terms, would not qualify for the homes, no doc loans. Everything that was happening at that point in time led to a massive recession. But all these other recessions that we've had, homes have actually gone up in value. So that tells you something about when people thought when we entered this new recession that we were going to have a major housing crash. It did not happen. So a big thing to think about is what has happened as far as the growth of home equity over this last year. So over the past year, strong home price growth has created a record level of home equity for homeowners. The average family with a home mortgage loan had $194,000 in home equity. Remember, it was $177,000 before last year, and that was in the 3rd quarter. This provides an important buffer to protect families if they experience financial difficulties, and is one of the reasons for the generational low in foreclosure rates. Also, there's a moratorium on foreclosures, but it doesn't change the fact that homes have a lot of equity. So what's happened? In last year, we had a $17,000 gain in equity of mortgaged homes. We had the current average equity of mortgaged homes be 194,000. Again, this is national statistics. And now 38.2% of all homes are owned free and clear. And there's a 10.8% increase in equity, totaling over $1 trillion. That's a lot of equity, and that's a lot of money that homeowners across our country have. And that's something we can all be really proud of, that we've helped people, especially our first-time homebuyers, entering the world of financial gain through them actually purchasing their first home. So here's a really interesting chart, I think. It's the year-over-year equity gains across our country. This is over last year. So in Oregon, there was a 23,000 gain in year-over-year equity from 2019 to 2020. So each state has its own value. The highest gains were in, obviously, Washington, California, and Massachusetts. But still, a lot of gain. I don't see any negative at all. Some of the lower gains, North Dakota, but still 5,000 gain. So the housing market has remained a strong pillar in an otherwise tumultuous economic year. A sharp rise in demand, spurred by record low interest rates, continues to bolster homeowner equity. And with many people now spending more time than ever before at home, some homeowners have tapped into their strengthening equity to fund renovations, which is one reason why we see places like Lowe's and Home Depot doing so well. People are into renovating their own homes. So the potential growth in household wealth over the next 5 years, based solely on increased home equity, if you purchase a $300,000 home in January of 2021, this is projected, but given this growth, we anticipate within 5 years, they will have gained $54,000 in wealth based upon price appreciation. And this is, and we'll go over that in just a little bit, kind of the expectation on what's going to happen with price appreciation. So what's ahead in 2021? So the surge in the work from home population has rewritten the playbook for many home buying and rental decisions, from when and where to relocate to what people are looking for in their next resident. And this is so true. We have seen this. This is what's caused Bend to become such a Zoom town, a place that people have been moving to. Because if you're going to be working from home, why not live where you really want to live? People have always wanted to be in Bend because of the lifestyle. Well, if you have a good internet connection, why not live where you are, where you can enjoy that? So despite the best intentions of home builders to provide more housing supply, the big short in housing supply will continue into 2021 and likely keep home price appreciation flying high. And that's from Mark Fleming, who's the chief economist at First American. And we see this within our own market here. So this is a projection of home price forecasts. This is all these different economists, different entities. So NAR projects a 6% national price increase in 2021. Realtor.com 5.7%, Freddie Mac 2.6%, Fannie Mae 2.1%. So, you know, there's some who are a little more conservative on it, but this is national stats still predicting that home prices will continue to rise in 2021. So the bright spot for buyers is that more homes are likely to become available in the last 6 months of 2021. I sure hope so. That should give folks more options to choose from and take away some of their urgency. With a larger selection, buyers may not be forced to make a decision in mere hours and will have more time to make up their minds. That would be very, very valuable. I hope that's the case. So what are we thinking about the economy? What's going to happen in the economy? So we have, the yellow line is what happened with unemployment rate. So we know when the pandemic hit, it was chugging along around 3.5%, really, really great, strong economy. And it tanked, it dropped down to close to 15% as far as unemployment rate. But then it recovered. We're now around 6.5%, 6.75%. The green line is what the Fed is predicting is going to happen. So they think it's going to take us 3 years to recover to where we were before COVID-19 hit. The Wall Street Journal thinks it's going to be more like 5 years before we recover. Now, the red line here is showing what happened in the Great Recession of 2006 to 2016, where it took us almost 9 years to get back to below 5% unemployment rate. So 3 years to recover fully, that would be awesome. Even 5 years, that's better than what happened during the Great Recession. So unemployment projections, this is where we are right now, 6.7%. The Wall Street Journal predicts 5.6%, and the Fed 5% in 2021, dropping down to in the 4s in 2022, and better in 2023. So let's hope this continues on. It's the more people working, obviously, the better it is for everyone. Unfortunately, it's renters who are disproportionately hurt by the crisis. And it's, again, a greater share of renters are the people who lost their jobs. That meant losing savings that could have been used for a down payment and falling behind in bills, which will hurt their credit and make it even more difficult for them to be future homeowners. But one thing to think about, there's still a thought process out there that you need 10, 20% down payment to buy a home. Something that people who are working with renters to encourage them and help them to become home buyers, letting them know about different loan options. We all know with Fannie Mae, VA loans, there's like very little down payment that's necessary. If you have a veteran you're working with, we know it's a zero down payment purchase for veteran home loans. Fannie Mae, FHA home loans, 3% down. So education on people would help them a lot. So for people who've actually, though, gone into missing their payments and who are in forbearance, here's projections about what's going to happen with post-forbearance outcomes. Of the percentage of 2.7 million homeowners who are in forbearance right now, this is the projection that 58% will resume their mortgage payments and stay in their home for at least 1 year. That 24% will list their home within 1 year of exiting forbearance. And then 18% will receive a foreclosure notice within 1 year of exiting forbearance. So the amount of people that will actually be foreclosed on is very small. It's 486,000. That's the projection. That's still a lot of people, but we know that even if they are in foreclosure, they probably have a lot of equity, and at the point of time when their home is sold, they may be able to walk away with money in their pocket if they have a realtor approach them with that, of listing their property, even if they can't make their payments. We did experience that last summer with one of our clients. He was in foreclosure, but at the point of time when we were successful in selling their home, they did walk away with money in their pocket. We got the seller was able to get the foreclosure postponed because we were, I don't know if we were at that point of, no, we had the listing. We weren't yet in contract, but we were able to get it into contract and get it sold, and they paid off their mortgage in full, plus all the penalties and interest they had connected with that, and again, walked away with money in their pocket. So something to think about here. So this is something, though, we have to keep in the back of our heads. Treasury rates have been moving up since the election, but mortgage rates have been kept going down. We're going to start seeing mortgage rates drift up with Treasury rates as opposed to moving in the opposite direction. That's going to happen. And what does that mean? Well, this is what it's going to mean. So say today you have a $300,000 mortgage at an interest rate of 2.7%. That means your payment is about $1,200 a month. If with the projection of the rate of increase in home prices by fourth quarter of 2021, that same house would be listed at $317. So say you got someone into their, or I should say their mortgage would be $317. And then the interest rate moving up to 3.4% would mean their monthly payment would be around $1,400. A difference of just under $200, that's significant. And in the life of the loan, a 30-year loan, that's $68,000. So that's why interest rates are as low as they are right now, we really should be encouraging people who are wondering when I should buy. If they are buying with a loan, this is an optimal time. It really is, if we can get them into a home, because the projection is that interest rates are going to start creeping up. Ending in this here, Jessica Lautz, who is, she works for NAR, she said, I do believe that the American dream of homeownership is very strong. It's very much alive from all of the survey data I've seen. If you're not a homeowner, you want to be one in the future, whether that's a short-term or a long-term goal. That is so true. People do want homeownership. So that, let's move to the last information, which is what's happened to us over this last year. So I'm looking at December of 2020 versus December of 2019. December is typically a very slow month for us. It is traditionally at a point in time where people are into the holidays. Listings are few. People wait till after the new year to start thinking about listing. So we increased our listings. Actually, it was not 200%, it would be 100%. We went from 4 to 8 volume up. Our pending sales, though, were down over 2019. And I can say the reason why they were down was because there was no inventory. It's not that we didn't write a lot of deals, and we did. We wrote a lot of deals in December, but the ones we actually got ratified were down compared with 2019, just simply because so much demand for the existing deals, existing listings. But we closed almost the same amount, and the volume of our closings were up 3 million over the year before. For our year-to-date figures, for 2019, we had 468 actual deals that closed at a value of 224 million. For 2020, we had 530 deals that closed for a value of 284 million. So a lot of work. I can say a lot of work, because of those 530 that we closed, we wrote twice as many of those that didn't go anywhere. We wrote over 1,000 deals in 2020, only closing 530, just simply because of the number of multiple offers written and things that just didn't happen. So when we look at the data from MLS on what's going on, as you can see, number of listings dropped significantly down. The number of new listings down, and the number of sold listings had dropped a little bit from, well, similar to what had sold in November. Listing prices, however, look at the average median list price shooting up tremendously. That's the active price. New prices and sold prices over 500,000. Absorption rate, less than a month's supply. It's significant. Sold to list ratio, 100%. Days on market, significantly down. And price volume, this is where we are with the active list volume. So there's just less inventory on the market. Look at where we were in February and March and April. Don't we wish we had that kind of volume of listings available? We just don't. So when we compare December 2020 versus December of 2019 with Ben's single family residential property, this is some of the significant thing. In 2019, we had 560 active listings. In 2020, we had 122. That's it. New listings. In 2019, only 76 new ones came on board. In 2020, we had double the amount of new listings hit the market. But look at the pendings, up 50% over 2019 as far as the amount of activity they were having. We sold roughly the same amount, just a little bit more. Volume up 32% over the year before. I think this is really significant. The average sales price, if you look at 478 in 2019 to 611 in 2020, up almost 28% as far as sales price. Median sales price up 17%. Percentage of list price, people are getting what they're asking for. They're getting 101% of what they're asking for. And again, months of supply, half a month of supply. again, a balanced market is 6 months supply. We've been averaging in Bend, for Bend single family residential homes on less than an acre of 3-4% regularly. Now with half a month, it's significant. If you look at the where people are buying in Redmond right now a lot. People are buying in Prineville. They just can't find things. And when we look at where we finished up the year, so this is where we are compared with other brokerages in Central Oregon. This is our sides. So we had 561 sides. So we had 530 actual properties that we closed, but we had on an extra 31 of them, we were on both sides of that transaction. So that means that sale is doubled. So that goes up to our volume of just under 300 million, which it's our best year ever. And so we are firmly entrenched in the number 5 spot. And when you consider that a lot of those people, those brokerages who are ahead of us, have maybe 2 to 3 times the number of agents that we do, the production out of a typical Bend Premier real estate agent is really significant. You guys really, really do well, and it's something to be very proud of and very encouraged by. And I'm thrilled with what you guys are doing. You really work hard. I would say that our biggest issue right now is inventory. I talk with all of you guys when I see you. You call me, you say you have 5 buyers you're working with, you just can't find property, or if you find it and you call on it, it's already pending. It's challenging times. How can we find property for your clients? In some cases, it's doing the old-fashioned way of writing letters to people who have property that may fit your client's needs that is not listed. And you can work with your favorite customer service department of your escrow company and say, this is what I'm looking for. Can you give me labels of properties that fit this criteria? And just approach these people. Find out if they are at all thinking of selling. And if so, because you have a client that might work for them, would they entertain someone looking? Have a single party. You may find that if they are receptive to it, you may actually even get a listing out of it. Maybe it doesn't work for your buyer, but maybe it would work for someone else's buyer. This can happen. It's an old method of trying to find something that's not an MLS, but it can work. So with that in mind, do we have questions? Anything to comment? Does anyone have anything that they want to share? If so, please feel free to unmute your mic and share that to the office. Any haves or wants that we can talk about? I know everyone has buyer wants. Anyone have anything else? Okay, well, if no one has anything else, then I can say just when will our annual top production 10 be announced? I'm going to work on that really soon, Eric. I wish I could have our party. I really do, our get together. This is really frustrating. I'm hoping, I actually wrote a letter to the governor and I asked her why we can't open our door. I haven't gotten a response back. I don't know why we can't have floor. I don't know why she specifically said that our offices have to be closed because Back Porch Roasters just down the street is open. Have people coming in to get coffee and leaving. I don't know why we can't have walk-ins coming in. We have volume in here, but we have to follow what the governor says. But yes, Eric, I will be working on that real soon. And I've got to figure out a way of having some sort of way of acknowledging all of you. I don't think we can have a get together. Obviously, we can't have any sort of luncheon like we did last year, but we will figure out a way of making sure you're getting acknowledged. And anything else for anybody? Any questions? Hopefully the changes to the forms make sense. If you have questions on that, let me know. Also, remember that forms are available on SkySlope as well as zip forms. And if you get to a point of being frustrated knowing how to renew your subscription on zip forms when it comes due, you can always renew it on OREF online, and then just go through SkySlope and get those forms and get access to the forms that way. All right, if I don't have any other questions, I'm going to go ahead and say goodbye, and let me know if you have questions. Thanks, everybody.